Well, anecdotally, you hear reports that these services are causing, or there's been an increase at least in accidents involving cyclists who are making deliveries. It raises the interesting question in terms of if a person riding a bike, or for that matter, driving a motor vehicle in the course of their employment as part of their work, and they're injured, which scheme are they covered by? Is it through the TAC or is it through WorkCover? And in terms of their basic entitlements to compensation, such as for treatment costs and for loss of earnings while they're unable to work, they're actually covered under the WorkCover system, or that's ordinarily how they should be covered. Sometimes there's a dispute with delivery drivers on whether it's motorcycles or on bicycles, whether they're considered to be workers who are employed by the particular company that they're delivering for. There's a trend these days for those companies to say, no, they're subcontractors and they're not covered by, we're not responsible for them, and we're not responsible for their work cover. That really is an illusion. They would be covered by work cover, or they should be. People who might be working in the gig economy, making deliveries for pizzas or as a courier around town using a bike or a motorbike, they would be considered workers and employed and covered by work cover. Now, it does become a question of degree to some extent of just how independent they are from the company that they are delivering for. And that can become a legal issue. But generally speaking, the courts don't accept this argument to say, well, they're just subcontractors, we're not responsible for them. If they're working under instruction from a company, they will generally be found to be an employee of that company. But it does sometimes become a question of degree. So my advice ordinarily would be that person should be putting in a work cover claim. If, however, it was found that they weren't an employee of the company because there was sufficient independence between what they did and when they did it and how they did it, that they didn't rely on instruction from the head company, if you like. They just delivered whatever they had to do when they felt like it, how they felt like it, and in their own manner. And it was considered, therefore, they were not an employee, then their rights to compensation would be through TAC. Now, sometimes in those situations, you can get a bit of buck passing. One saying it's not us, it's the other, and then vice versa. Well, that's just something that you have to look at the particular circumstances of the arrangement and the employment and sort that out. I think it'd be important to see a lawyer, because in those situations, it's not uncommon for the body or the company that we might say is the employer denying they are in fact an employer. That's certainly not uncommon. And in that situation, a person really should see a lawyer to have that sorted out.